Hello friends, in the series on the income tax cases, today we will discuss the case of Sylvesa Infotech Private Limited versus Additional Commissioner of Income Tax and another. This case has been reported in 457 ITR at page number 433. The matter has been decided by ORISSA High Court and the date of the judgment is 1st November 2022. Friends, this case is again regarding section 148 notices and the filing of the writ petition by the assessee against the notices issued. As all we know that the maximum litigation is in respect of section 148 notices. The jargon of section 148 notices has become so complex that even for the department, for the assessee, for the professional and even for the courts, it has become a headache, and the assessee has to face a lot of litigation because of the uncertainty, because of the complexity which has been created in section 148 notices. The law which was settled has been desettled. I do not know what is the purpose of that. Already the Supreme Court judgment of JKN drive shot was there. Everything was settled, but with the introduction of the new section 148A, the nuisances of this section has become more complex. In this case, two assessment years were involved, assessment year 15-16 and 16-17. The notices for both the assessment years were issued under the old regime on 31st March 2021. For the reasons best known to the department, another set of notices under section 148 was issued on 8th April 2021 in new regime. The assessee do not have the choice other than for going into the writ petition, because now the assessee has two set of notices. The assessee was in a dilemma that which set of notices to be pursued, and the legality of this aspect is to be checked, that whether the department can issue two sets of notices under section 148. The assessee filed the writ petition in the ORISSA High Court by challenging both set of notices issued under section 148. When this matter came before the ORISSA High Court, the department pressed the first set of notices. As far as the first set of notices was concerned, the permission of Additional Commissioner of Income Tax was taken for issuing the notices under section 148 for the assessment year 15-16 and 16-17. It was the plea of the assessee that for assessment year 15-16, the permission of Principal Chief Commissioner of Income Tax is to be obtained, and for the assessment year 16-17, the permission of Principal Chief Commissioner of Income Tax is to be obtained. But for both the years, the department has obtained the permission of Additional Commissioner of Income Tax, so these notices are liable to be quashed. As far as this aspect is concerned, the court was convinced with the assessee and the court quashed these notices. Now, if we come to the second set of notices, those notices were also issued with the permission of the Additional Commissioner of Income Tax, and in those notices, the mandatory procedure of prior inquiry was not followed. So, since the permission of the required approving authority was not obtained for the second set of notices also, and the mandatory procedure of prior inquiry has not been followed, and even the department was not pressing those notices, so those notices were also quashed. But as a rider at the end of the order, the ORISSA High Court gave a liberty to the department that if the department has the time to issue the notices, then they can do so by following the due procedure of law. Friends, although the assessee got the relief, but when the department has already issued two sets of notices, both the sets of notices have been quashed. So in these cases, it is very harsh on the assessee, it is very painful for the assessee that again the liberty is given to the department to issue the notices. So it means that the assessee has no end for the litigation. It is an ongoing process and the assessee has to face the pain of that. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Sylvesa Infotech Private Limited versus Additional Commissioner of Income Tax and another. And this case has been reported in 457 ITR at page number 433. The matter has been decided by Orissa High Court and the date of the judgment is 1st November 2022. Thank you, friends.